there was a suit filed for mandatory injunction and also permanent injunction against the defendant and the BBN at the now BBN corporation. The case of the plaintiff was the defendant has put up a construction in the middle of the road by which the plaintiff cannot go through in that road. Road madhye building katbididana elli Chamarajpete. Therefore, the BBMP has also not taken action. Mandatory injunction directing them to demolish the building, illegally constructed, and permanent injunction not to put up any further construction in that road. It's a public road. Then he came to know that is not only causing inconvenience to the plaintiff, but also to all the nearby residents who are making use of that road. Road use ಮಾಡೋರು ಎಲ್ಲರಿಗೂ ತೊಂದರೆ ಆಗ್ತದೆ. ಅಲ್ಲಿ 2 wheelers ಬಿಟ್ಟರೆ ಯಾವ ವೆಹಿಕಲ್ ಓಡಾಡೋಕ್ಕಾಗಲ್ಲ. Then he sought the permission of the court and ordered 128 to convert that suit to a representative suit. Then court allowed that, and the procedure that has to be followed in representative suit is issue a public notice. The court has to issue a public notice calling the public to join the suit, either to support or oppose. So Order 128 also speaks about that. And if the defendant has got any objections with regard to non-joint of necessary party, he should raise that objection at the earliest point of time. Subsequently, he may not be permitted. So once you know who are the parties to be made in the suit, then the question as we have started, where the case has to be filed. In a civil court, the hierarchy of the civil court which we are all familiar with: small cause court, civil judge junior division, civil judge senior division, district court, high court, supreme court. As far as small cause courts are concerned, it has got very limited jurisdiction, which we are all familiar with. I think in Bangalore, small cause court only recovery of money which are below 2 lakhs. Now it is vested with the jurisdiction of deciding the cases of MAC, workmen compensation, and also 138 cases. Any act. And also HRC cases, eviction cases, another in Karnataka and Act. Apart from those type of cases, the small cause court has no power to deal with other cases. Coming to the civil judge junior division, senior division, they have got 2 types of jurisdiction. One is pecuniary jurisdiction, another is territorial jurisdiction, and all these courts are about subject jurisdiction. 3 types of jurisdiction. Section 6 of the Code of Civil Procedure deals with regard to pecuniary jurisdiction. As we are all familiar with, a civil court junior division can deal with regard to suits the value of which is less than 5 lakhs. Right? Only below 5 lakhs, we can go to the civil judge junior division. If it is above 5 lakhs, to the senior civil judge. What is the upper limit? How many lakhs?
10 lakhs.
Upper limit 3 lakhs. Or 5 lakhs can just
10 lakhs. 10 lakhs.
1 crore.
How much? Maximum 10 lakhs, huh? 15 lakhs, huh? 2 lakhs, 20.
I got it.
There is no upper limit. As far as civil judge senior division is concerned, there is no upper limit. Only restriction to go to civil judge senior division is you should be more than 5 lakhs. Whatever may be the value of your suit, 10 lakhs, 10 crores, 100 courts, only civil judge, senior division. There is no upper limit. And in our state, High Court has no original jurisdiction. In some of the states they have got. I was told in Bombay High Court they have got original jurisdiction, where if the value of the suit is more than a particular amount, you can straight away file a suit in High Court. But not so in our Karnataka. Coming to territorial jurisdiction, section 15 to 25 deals with regard to territorial jurisdiction and also transfer of cases. Section 15 says a civil case has to be filed in the lowest court which is competent to try. Two conditions they will impose. One is it should be lowest court. Another condition is that court should be competent to decide this particular suit which we are going to file. To give example, to make more clear, if you value your suit or your suit valuation is 4 lakhs, naturally the lowest court and which is competent to try is jurisdictional. On the other hand, if your suit is valued 10 lakhs, then quite naturally the lowest court which is competent to try. Two conditions should be fulfilled. Civil judge, senior division. So that is why in almost all cases we value the suit for two purposes. You remember, one is for the purpose of jurisdiction, peculiar jurisdiction. Another one is for purpose of court fees. That is, for example, suit for injunction. Suit for injunction. If you value your suit for the purpose of jurisdiction, that property less than 5 lakhs, you have to go to the junior division. If you value your property more than 5 lakhs, senior division. The prayer is the same. Injunction, permanent injunction. But court fees, 25 lakhs. Permanent injunction. Section 26, right? Of the Karnataka Court Fees and Suits Violation Act. So, for two purposes, always we value the suit. One for jurisdiction, peculiar jurisdiction, another one for court fees. Then section 16, 17 and 18. All these provisions deals with regard to the immovable property, suits pertaining to immovable property. Where the suit pertaining to immovable properties have to be filed. As we all know, it has to be filed where the property is situated. The immovable property is situated. That is what section 16 says. 17 says, if the properties are situated in more than one place, one property is in Bangalore, another property is in Mysore. In any one of the places you can file. It is the choice of the plaintiff. If you want to see Karaga, file it in Bangalore. If you want to see Dasra, Chamundeshwari, file in Mysore. No, there is a ambiguity. I am not certain in which place I can file this suit pertaining to immovable property. This provision I always highlight because the lawmakers think from all angles, all possible situations that may crop up in the future in a particular case or situation, and then they will make laws. For that, this is the best example, which is that section 18. Normally, what we feel, what is the ambiguity pertaining to an immovable property? It should be situated in one place. So you are going to file in that case. But as an answer to that, I got a case. I always remember that case very long back. There is a village called as Nagareshwara Naganadi. Some of you might have heard Where is that situated? On the border of Bangalore city district and rural district. Adding to this, the suit scheduled property is also situated on the border. Portion of it comes to the rural district, portion of it comes to the urban district. The question was where it has to be filed. If you want to file it in rural court, you have got junior division, senior division. District court is also there. Whereas in urban district, city district, only city civil court, all in one. So we are deprived by one appeal. Whereas in the rural courts, rural district, where they have got one appeal. RA to the civil judge, senior division, or to the district court as the case may be depending upon the value, then second appeal to the high court. But as far as the judgments passed by the city civil court, RFA up to the high court only one. One appeal is deprived to the Bangalore city district. So what 1918 says, if you are not sure in which court you can file, you file in any one of the courts, either in the rural court, district or city court. But the court in which you file the case should give a finding. This is the ambiguity expressed by the plaintiff, but this court also has got a jurisdiction to decide this case. Therefore, I take the file on my board and continue it. Once that finding is given, so that is pertaining to immobile property, 16, 17, 18. What about the cases other than the immobile properties? That is wrong done to a person or thing. This happens normally out of emotions, especially in villages, for getting water to their lands from canal. Melgadam upper landowner will stop the water. The person next to him will not get the water. Fight starts, emotion or charge. Or if any person who is short-tempered, if you just says few opposition words, you will be triggered. Most dangerous. Again, I remember Mata Amrutamai, I was quote that if you hate or get anger against anybody, the first victim is yourself. If you get anger and hate any person, the first victim is yourself, because your BP will be raised. You will get all the diseases out of BP, temperament. It is as good as consuming poison and expecting your enemy to die. ಈ ದ್ವೇಷ ಮತ್ತೆ ಸಿಟ್ಟು ಅನ್ನೋದು ಹೆಂಗಪ್ಪ ಅಂದ್ರೆ ನಾವೇ ವಿಷ ಕೊಡೋದು ನಮ್ಮ ವಿರೋಧಿ ಸಾಯ್ತಾನ ಅಂತ ಕಾಯೋದು. It is not me, I am going to die first. So we should be always very careful. That's why they say that don't speak anything when you are angry. Because we will be losing our control. Senses. Just we will do whatever comes to our mind in that emotion. That will create hell of a problem to all of us. You might have experienced, all of us have experienced that, either ourselves or with our friends or our family members. Small issues which trigger the emotion. During that emotion, if they take some action, disaster, which cannot be repaired so easily. So under such circumstances, any damage done to a person, you will hit him, or somebody hit some person, lose his teeth, admitted to hospital, spend money, vehicles are damaged, wrong done to a person or thing. He will not keep quiet, he has lost his health or leg or hand or his vehicle, he will file a case, apart from criminal case, where it has to be filed. For that section 19 is the answer. 19 says, 18 is the one which I said where there is ambiguity need to file the case. 19 is the one which deals with regard to cases to be filed pertaining to wrong done to a person or thing. So it says such cases have to be filed where the incident has taken place. That particular incident has taken place due to which the person has been incurred injury or his property has been damaged. That place, if in Bangalore it has been done, in Bangalore you have to file. If in Bangalore it has been done, there it has to be. Or where the defendant or defendants are present, there it has to be filed. Last one, very, very confusing one. That is, other than these types of cases, wrong done to a person or thing, or pertaining to immobile property, other cases where they have to be filed. Which are the other cases? That is, like contracts, sale of goods. Here, you will get some confusion. Once you know the principle, then automatically you will be familiar with that. Why confusion? Because choice is more. For ladies also it happens. Because if they get more choices finished, they will not come out of the shop. They want all the matching things. So like that, in a case, if you have got more choices of places to be filed, then the confusion starts. For that I always give some examples. Like, if a person from Bangalore, businessman, goes to Delhi, attend a conference, where another person from Calcutta comes, businessman, there they will enter into a contract. The Bangalore person is a wholesale dealer in cloths. So they enter into a contract. The Calcutta person, businessman, agreed to purchase worth 60 crores of cloths and 30 crores advance were given. Remaining amount will be given after delivery of the goods by the seller in Bangalore, purchaser in Calcutta. Contract was done in Delhi. In addition to that, the purchaser said, you see, I got a showroom in Bombay. You should deliver the goods to Bombay. Then the purchaser, seller said from Bangalore, fine, everything is fine. What about the remaining 30 crores? This is a business. I want some surety, solvent surety. Fine, no problem. I've got a friend in Chennai, very close friend, very solvent. Who is that? Rajnikant. Okay, fine. It is solvent. Nobody can dispute it. So now we have what? Seller is in Bangalore, purchaser in Calcutta, contract was entered in Delhi, goods were delivered in Bombay, surety is in Chennai. Fine. Now the goods were delivered, 30 crore balance was not paid, client comes to you, seller asks, this is the thing. So you got a very good case, very heavy case. Don't worry. These are one of the solve choice. What we'll do? Let us say we will issue a notice. What he will say. So we will issue a notice. The purchaser sends reply to that from his attorney at Calcutta, who says that your client has delivered defective cloths which are of worst quality with damaged, due to which my client has suffered loss. There is no question of giving any 30 crores to your client. It is your client who has to give damages to my client. Reply has come. Now case has to be filed. Where the case has to be filed? Simple. ಒಂದಾಗಿದೆ ತೆಲುಗಿಲ್ಲ. ಈಗ ಜಾಸ್ತಿ ಪ್ಲೇಸ್ ಕೂಡ ಇರೋದ್ರಿಂದ there are more places, then the problem starts. So where it can be filed the case? They may give an illustration to you in the exam. Please advise the plaintiff where he can file the suit. Now, further we will say, defendant, he took your advice and filed the suit in Bangalore, city civil court. It has got a jurisdiction. City civil court, there is no maximum pecuniary jurisdiction. Alva, city civil court will have in Bangalore city civil court. Defendant raises an objection. No, this court has no jurisdiction. To raise that objection, section 21 says, if the defendant has got any objections with regard to the jurisdiction of the court, territorial jurisdiction, it has to be raised at the earliest time. Section 21. 21 capital A further says, once the defendant allows the suit to be decreed in a court which does not have the territorial jurisdiction, then the defendant cannot file a suit challenging the judgment on the ground the court which passed this decree has no territorial jurisdiction. Section 21 capital A. 21 further says he should not be permitted to raise that objection either in the execution or in the revision or in the appeal unless he satisfies the court by such case being filed in that court, he has been prejudiced. So he should raise that objection at the earliest point of time. Section 21 capital A bars him from filing a further suit, challenging the judgment. Once he fails to raise that objection. Here itself, we will also examine Order 7 Rule 10 of the Code of Civil Procedure. Order 7 Rule 10, which is also one of the important provisions from the point of view of your examination, where it deals with regard to return of plaint. Order 7 Rule 10, whereas Order 7 Rule 11 deals with regard to rejection of plaint. Till recent times, we used to file an application under Order 7 Rule 10, raising the objections with regard to the jurisdiction of the court, whether pecuniary or territorial. But because of Justice Kumar's judgment of our High Court, where the court said there is no scope for filing any application under Order 7 Rule 10 with regard to raising objections of the court for pecuniary or territorial jurisdiction. Then how that objection has to be raised? For that the court has answered stating that you have to raise this objection in your written statement itself. What the people used to do earlier was, under the pretext of raising this objection, they used to drag defendant. File an application, this court has no jurisdiction. Let the court decide that application. Objection, arguments, orders, either challenge them by way of division petition earlier, now writ petition. So it will be dragged. So he said no. Under Order 7 Rule 10, there is no scope for filing the application for raising the objection. You have to raise in your written statement. You file written statement, in that you raise. Or else you raise at the time of framing up the issue under Order 14. So that is the present position with regard to raising objections pertaining to jurisdiction, pecuniary or territorial jurisdiction. When such an objection was raised by the defendant, the court has to decide. So now, under Order 7 Rule 10, we all know the court has no power to dismiss the case. Court has got power only to return the plaint, asking the defendant, the plaintiff, to present before the proper court. And it also does not give any opinion. You file in this court, you file in this court. No. It is not its business. It is for the party to decide. But this court has no jurisdiction to decide the case. Now tell me, under this facts of the case, whether the objection raised by the defendant is to be allowed or not. If it cannot be allowed, why? If it can be allowed, why? How? And where the case has to be filed. In these types of litigation. Now we have got chance. Bangalore where the plaintiff is there, Calcutta where the defendant purchaser is there, Delhi where the contract was entered into, Bombay where the goods were delivered, Chennai where the surety is decided. Whether this objection by the defendant is correct. If not, where the case has to be filed. For that, we should go to section 20 of the Code of Civil Procedure. Section 20 says, other than these types of cases, the suits have to be filed where the cause of action has arisen either partly or fully. It will not stop at that. It further says, where the defendant or defendants are carrying on the business or residing. So, we should apply that to this particular case. First one is where the cause of action has arisen, partly or fully. Cause of action has not been defined in the Code of Civil Procedure. Based on the decision of the Supreme Court, we have to understand the word cause of action. That's most important. To file any suit, there should be a cause of action. What is the cause of action? If a fact is alleged and is proved, the plaintiff should get the relief. Such facts constitute cause of action. That's why the Supreme Court says bundle of facts put together is called as cause of action. Bundle of facts put together. All those facts, if they are capable of proving or if it is proved by the plaintiff, and he will get a relief. Such facts put together are called as cause of action. To make it more clear, I always compare this cause of action to mind. What is mind? Everybody knows. I know mind. Isn't it? Manasu. Everyone got it. But when they ask, show your mind. Please show me your mind. Can we show? Then what is this mind? All the scholars, philosophers, spiritual persons have said, mind is nothing but thoughts. Bundle of thoughts, bunch of thoughts put together is called as mind. And if you just observe yourself, or if we observe ourselves, there is no gap between one thought to another thought. Continuously, without a fraction of a second, there is a gap between one thought and another thought. One thought is about to stop, it is already there, another stop. ಒಂದು ಸ್ವಲ್ಪ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಜಾಮೂನ್ ಚೆನ್ನಾಗಿ ಕಾಣಿಸ್ತದೆ ಅಂತ ಮೈಸೂರು ಪಾಕ್ ತಂದು ಅದು ಭಾಳ ಚೆನ್ನಾಗಿತ್ತು. ಅದಾದ ತಕ್ಷಣ ಇನ್ನೊಂದು ಹಲ್ವಾ, ಬಾದಾಮ್ ಹಲ್ವಾ, ಇಲ್ಲ ಐಸ್ ಕ್ರೀಮ್ ಅಲ್ವಾ, ಅದು ಒಂದೇ ಉದಕ್ಕೆ. ಯಾಕೆ? ದೇರ್ ಇಸ್ ನೋ ಬಾರ್ ಫಾರ್ ಅವರ್ ಥಾಟ್ಸ್. It can freely roam without any charge. If you want to go to Bombay, yes, just you are there. Delhi, yes, you are already there. Moon, Jupiter. Think of it, you are already there. So fast, no expenses. That is the power of the mind. That is why I always remember, you know that Swami Vivekananda's words, how powerful the mind is. It is like a rays of sun. If you concentrate those sun rays through lens on a piece of paper, it will burn. That is the power of our thought. Only thing is we have to make use of that power. That is why they say, concentrate your mind on one task at a time. You will succeed. Simple formula. ನಾನು ಅದನ್ನು ಮಾಡ್ತೀನಿ ಇದನ್ನು ಮಾಡ್ತೀನಿ ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅಲ್ಲೊಂದು ಕಾಲು ಇಲ್ಲೊಂದು ಕಾಲು ಇಡಬೇಡ ಎರಡು ಕಡೆ ಒಂದು ಬಿದ್ದು ಬಿಡುತ್ತೆ ಕೆಳಗೆ. ಯು ಹ್ಯಾವ್ ಎ ಕ್ಲಿಯರ್ ಗೋಲ್. Concentrate on that. Definitely you are going to succeed. That's what Swami Vivekananda says. So that is how the bundle of facts put together is called as cause of action according to the Supreme Court. So in our case, a part of cause of action has arisen in Delhi, where the contract was made. Other part of cause of action has arisen where goods were delivered to Bombay. So we can file either in Bombay or Delhi. Or where the defendant or defendants are residing. The purchaser is in Calcutta, you can file there. Surety is in Chennai, you can file there. But in this particular case, you cannot file case in Bangalore because of section 20. Neither the cause of action part carefully has arisen in Bangalore, nor defendant or defendants are residing or carrying on business in Bangalore. Therefore, the Bangalore court has no jurisdiction to decide this case. Peculiar technical cause of action, section 20 part. But there is another defense of the defendant, plaintiff. No, we have got a contract. Please look into the contract we have entered into. There is a clause. What does it say? It says, if any dispute arises out of this contract, all such disputes are subject to the jurisdiction of Bangalore City Civil Court. Therefore, this court has got jurisdiction. That is, our arguments may be urged by the plaintiff counsel or plaintiff. Can we accept that in this case, if the plaintiff put forward that argument, Supreme Court says no. Why? Because Supreme Court has said in many decisions stating that parties by agreement or consent cannot confer jurisdiction on the court which does not have. Parties by consent or by agreement cannot confer jurisdiction on a court which does not have jurisdiction. According to section 20, Bangalore court does not have jurisdiction in this case. So if you have a contract, it is illegal against law. Contract Act does not permit you to have such a contract. If you have that, it is illegal contract. Therefore, you cannot have a consent or an agreement conferring a jurisdiction on a court which does not have in the eye of law. On the contrary, if you were to have a clause in your contract, in the same illustration case, all disputes arising out of this contract are subjected to the jurisdiction of Bombay City Civil Court or Bombay Court or Delhi Court or Calcutta Court, then it is valid because section 20 permits, it is not illegal. So if you have got a choice to file a suit in different courts which is permissible under law, then only such clause is valid, not otherwise. Is it clear? ಕಾನೂನಿನಲ್ಲಿ ಸಮ್ಮತಿ ಇರಬೇಕು ಅದಕ್ಕೆ. ಆ ಥರ ಇದ್ದಾಗ ಮಾತ್ರ ನೀವು ಆ ಷರತ್ತನ್ನು ಹಾಕ್ಕೊಂಡು ಒಪ್ಪಂದ ಮಾಡ್ಕೋಬಹುದು. ಕಾನೂನಲ್ಲಿ ಅದಕ್ಕೆ ಮಾನ್ಯತೆ ಇಲ್ಲದೆ ಇದ್ದರೆ ಕಾನೂನು ವಿರುದ್ಧವಾಗಿ you cannot have a contract agreement. That's how we have to do. So next comes transfer of cases. 23, 22, 23 deals with the transfer of cases where parties have got scope to file cases in different courts. 24 and 25 deals with regard to transfer of cases even though you do not have any option to file cases in other courts. A different situation I think. Here, in this illustration, where the party can file in different courts except Bangalore, if the plaintiff files a suit in Bombay, the defendant can make use of section 22 and 23 and request the court, no, I cannot come. The defendant who is in Calcutta can request the court, no, for this reason, I am not able to appear before this court in Bombay. Please transfer this case to Calcutta. He can request, but it is not mandatory for the court to accept that. No, it is a discretion of the court. Court will look into his request. Is it feasible and helpful and good for all the defendants and parties, plaintiff? Then only court will order, and that order should be passed judiciously. All the orders, remember, the court has to pass judiciously in accordance with law, not whimsically, not illegally. It should be judicial order. Application of the mind should be there, confined within the corner of the laws, and it should be judicious. But they have got right to seek, request, make a request under section 23, where the plaintiff or the case should be filed or may be filed in more than one place. Now considering section 24 and 25, where it deals with regard to different situations altogether. Even though he has no option, but he has filed a case, like a suit pertaining to immobile property. It has been filed with the property suit. It happened in one cases, eviction cases. Landlord filed an eviction cases in Chitradurga court against the tenant. He was horrified because it was not coming to an end at all. Then on inquiry he came to know that tenant is working in the district court Chitradurga. He was sure of two things. One is my case will not be concluded shortly. And then even if it is concluded, definitely it is going to be against me because he is working in the district court itself. It is normal for human tendency. He will think like that only. Alva, naturally he will think, court nalli kelsa madi inda agutta nammu parva kelsa your case. Then he came and approached his advocate. Then he said, okay, fine, he give all the details. And he filed a petition before the High Court. So if you want to get the transfer of a case within a district from one court to another court, section 24 gives power or right to the district court. Within district. In that particular case, if the landlord wanted the case to be transferred from Chitradurga to Chalikere, which are in the same district, he should file a petition before the district court. But if he wants to get the case transferred to other district than the one in which district his case is pending, court, then he should approach the High Court on section 24. So 24 gives power to the district court to transfer from one place to another place within its district, that district, to High Court to transfer the cases from one district to another district. In this particular case, the landlord made an allegation that he don't want the case to be transferred to any of the places in Territorial district because he is working in district court. All other courts are subordinated to the district court. He wanted the case to be transferred to other district, any other district than the Chitradurga district. This matter came up before Justice Nawadgi, the father of the present Advocate General. I was there that day. Wonderful judge, K.P. Nawadgi, very gentle, very soft spoken, wonderful English, very respectful. Whoever goes to the junior sir, yes sir, please tell me sir, use letters, youngsters also. And very thoroughly known all the laws, especially civil litigation. He asked only one question to the tenant's advocate who was the respondent. The notice was served and they appeared. Asked whether your client is working in this district court. He said yes. Then immediately, then I am going to transfer. Then he was shocked. Tenant said, no, oh my Lord, the judge is very pious, very sincere. No, I am not talking about his integrity. I am not questioning about his integrity. Think for a moment. If the landlord petition is going to be allowed, no problem. You will be happy. If it goes against him, against the landlord, even though on merit the judge passes the order, he does not have merit, he has not proved that he required the premises for his bona fide use or occupation. On merit he dismisses the petition. What will he tell the landlord to others? No, I was knowing. The tenant was working in the district court. He has an influence. I don't want that to happen. Therefore, I am going to transfer. And that was transferred to Tumkur court. Similarly, 25 gives power to the Supreme Court to transfer from one state to another state, a civil case. A similar provision also is there in section 405, I think. 405, yes. And 406 within the state. CPC. That is how the Jayalalitha case was transferred from Tamil Nadu to Karnataka state. Because they said their government is working in power. We won't expect any justice in that state court. That is how the Supreme Court ordered for transfer to Karnataka court, Jayalalitha's case. So like that, if there is any allegations, even with regard to the presiding officer, if it is made to the district court, he will call for the report. If it is made to the high court, any allegations made to the presiding officer, court will look very seriously about that. Immediately will not transfer. Because tomorrow everybody starts those allegations. Court will examine, take the report from the presiding officer, then only court. But the courts have got power to transfer. So this is how we have to deal with regard to territorial jurisdiction under section 15 to 25, including transfer. I think I have taken much of your time. I will stop at that.